Good evening, everyone. Thanks a lot for such a good response, and we have a good number of participants. And as we all IPs, I rightly appreciate Mr. Rajesh also who joined this webinar. Like many others are also joining, even though they are not IP, because insolvency IBC code is so much having impact on entire company and economy ultimately that each professional who is dealing with the corporate or a business house need to know what is IBC, because anytime, anywhere it will affect your client or your own business. And hence, the development in this case or this code is need to be understood by each and everyone. Our efforts is to keep updated and work on all this new development. And one of this is today's topic we have taken, that Supreme Court judgment, which was quite discussed, that it is, our topic is Supreme Court judgment on Okhla Industrial Development Authority versus Anand Sonbhadra dated 17 May 2022. Since it is recent one, I thought that we should take it because it has clarified many issues, and hence we can discuss it in depth. Our duration is 1 hour. We'll try to finish it as in 1 hour only, and we will invite the question in the chat box at the time when the presentation is going on. Our presenter is Jasveen Bindra. She is partner of Mehta Company Secretary. And of course, our panelist is Mr. Ravi Prakash Ganti. Everyone IPs knows, and many people knows him. Just brief introduction about Mr. Ravi Prakash Ganti, though he's a big personality. His experience is a wide and intensive experience of more than 35 years across various industry sectors: consumer durable, industrial components, seafood, chemicals. Functional experience in marketing, purchasing, production and quality, finance, HR, legal and compliance in large listed companies, not a single department left. Head board, CEO level position in 2 listed company, currently liquidator and earlier RP of 9th corporate debtor in real estate sector, and advisor to liquidator and RP, 3 separate matters. By education, Friend is BTech Honors in Metallurgical Engineering from IIT Kharagpur, PGDPM, Postgraduate Diploma in Business Management from XRLI Jamshedpur in 1981 with specialization in marketing and finance. And yes, something great, LLB final student. And best of luck for your result. I know you will clear only. And special knowledge, business process, re-engineering, and theory of constraints. Is regular faculty in IBPI pre-registration course for IPs and IIPDP course for IPs. Welcome, Mr. Ravi. Thanks a lot for your time and sharing. It's really a privilege for us and all the participants. And without Mr. Ravi, you would like to take something on the topic or your view of the topic, then we can start, or parallelly you will take it.
I would say let the presentation be over. Okay, then we will chip it with our views. So we will preempt the presenter. फिर वो बोलते हैं ना, introductory person will give the speech. ऐसा नहीं होना चाहिए. Let the presentation be complete. Yeah. Okay, then we will.
Okay, Jasveen, you can start the presentation. Start screen sharing.
Yes, ma'am. Thank you. Thank you so much. So we are discussing the Supreme Court judgment of New Okhla Industrial Development Authority, which is NOIDA, as it is abbreviated, versus Anand Sonbhadra. So the date of this judgment is May 17th, 2022. And this judgment was delivered by Honorable Justice K.M. Joseph and Honorable Justice Rishikesh Roy. So these constituted the bench of the Honorable Supreme Court and delivered the judgment. Now, this is a common judgment in 2 appeals, which is 2222 of 2021 and civil appeal number 2367 to 2369 of 2021. This is a common practice that if any 2 or more appeals deal with same question of law being involved, then the same are clubbed and a common judgment is delivered for the same. So let us first understand what do these 2 appeals differently deal with. So what was the context, or what was the contention in these two appeals? So first being the civil appeal number 2222 of 2021, wherein Noida had applied to the resolution professional. Initially, they had filed a claim as an operational creditor under the CIRP. Later on, they revised their claim and filed a claim as a financial creditor during the CIRP process with the resolution professional. Now, this matter went up to the to NCLT for decision, wherein the NCLT said that Noida cannot be treated as a financial creditor since the transaction is not a financial debt. Like we all know, financial creditor is anybody who has given a financial debt to the corporate debtor or to whom such debt is assigned. So they said that since this transaction does not involve a financial debt, therefore Noida cannot be treated as a financial creditor. The judgment of the NCLT was appealed before the NCLAT, and the appellate authority affirmed the view of NCLT. That is, the NCLAT also held that no, Noida cannot be held to be a financial creditor. Now, this NCLAT judgment was appealed further before this Honorable Supreme Court of India. This is the subject matter of the context in first appeal. In the second appeal, which is civil appeal number 2367 to 2369 of 2021, it again involved the same issue that Noida had appealed. That is the appellant in this case. Noida had said that Noida should be treated as a financial creditor in the CIRP process. The only difference is that in this case, the NCLT had actually held that the authority, which is Noida, should be treated as a financial creditor. However, the NCLAT had passed an order staying this order of the NCLT. So they had stayed the order, which means the NCLT order could not be operative. This stay order was appealed before the Honorable Supreme Court in this matter. So like we all can understand, the common question of law or the main question of law involved in these appeals is whether the appellant, which is Noida, is entitled to be treated as a financial creditor within the meaning of IBC. This decision has gone deeper into a lot of aspects and definitions per se of the IBC, dealing with section 5.8, which is the definition of financial debt. So it is discussed in great detail the scope, ambit, and the context of financial debt under this definition, under this section, which is section 5.8. Thereafter, section 3.11, which is the definition of debt, has also been dealt with. Section 3, subsection 6, which is definition of claim. And the last definition that has been dealt with quite extensively is section 3, subsection 33, which is the definition of a transaction. We'll understand how they have deliberated upon each as we go forward. So first, it is important to understand the brief facts of the case. We won't be going in too much depth of the facts because it is on a per case basis that we have to deal with. But briefly, to understand or appreciate the law, we have to understand the facts of each case. So in this case, a land parcel was owned by Noida. Noida, which is New Okhla Industrial Development Authority, is an authority established under the Uttar Pradesh Industrial Area Development Act 1976. So for anyone in Maharashtra, it is quite easy to understand it like in the MIDC context. So like we have MIDC in Maharashtra, a similar authority is present in the northern area known as Noida. So this property forms a part of the land acquisition under the Land Acquisition Act. So this is held completely by Noida, and the development by the lessor, which is Noida, was only for the purpose of setting up urban and industrial township, which meant that the land parcel was to be owned by Noida, and Noida had the authority to look after the development of that area, either forming urban areas or industrial townships in that particular area. Now, this leasehold property, that is the land parcel, was given to the corporate debtor on lease by way of a bidding process. And the purpose of this bidding or giving lease of the land was for the construction of residential flats according to the plan that was approved by Noida. The period of lease was 90 years. This is important in one of the contexts which will be discussed later. And the terms of the lease were such that the corporate debtor had to make an upfront payment of which is known as the down payment of 10% of the total lease consideration. That is the premium. And there was also a moratorium for the payment of rent for a period of 2 years as per the terms of the lease deed. So, and the lease deed also imposed certain other conditions upon the lessee, which is the corporate debtor in this context, such as restrictions relating to its shareholding, use of the property, etc. So there were a lot of conditions imposed by Noida, which is the lessor. Okay. The main matter involved, the subject matter of the lease deed was the land parcel, and it involved rights and liabilities of the person, of the lessor and the lessee in regard to that land parcel only. Now, once the lessee, which is the corporate debtor in this context, constructed the residential units, so that was the purpose, right? Like we had highlighted in the lease deed, what they had to do is they had to construct residential units. Once these residential units were actually developed by the corporate debtor, they had the right to sublease it to the to sublessees, right? So again, subject to certain conditions. The terms were also imposed by Noida for this sublease. So in certain cases, they had said that this sublease can only be for a residential purpose, and it can be only to Indian residents. So these were some terms of the sublease wherein Noida also exercised the right and discretion and imposed certain terms and conditions upon the sublease. The sublease does not deal with the land. For the sublease, the rights and liabilities were limited to the residential units or the dwelling units that were actually constructed by the corporate debtor. So these are some brief terms of the lease deed that were noticed or highlighted in the judgment. The next point which is to be discussed is the contention of the appellant, that is Noida, was that they wanted to be treated as a financial creditor. The question that arises is, why were the appellants or Noida so insisted upon being included as a financial creditor? So anyone, all the IPs in the webinar would definitely appreciate and know that financial creditors do enjoy certain rights under the IBC, which are above the operational creditors, or maybe what operational creditors do not. So some of them are section 21, wherein COC shall consist only of all unrelated financial creditors. So which means that financial creditors do form a part of the COC. And the COC has the right to appoint and replace the interim resolution professional as the resolution professional. Thereafter, section 27 also provides that the COC can actually replace the resolution professional as well. Then section 28 provides that approval of COC shall be mandatory in respect of certain powers that are to be exercised by the resolution professional. So resolution professional can exercise those powers only subject to the approval of the COC. COC meaning the body of financial creditors. Section 30 says the most important power, the resolution plan, is required to be considered and approved by the committee of creditors. Resolution plan is the most important part wherein the CIRB process actually culminates or ends up to, which means that if the plan has to be approved or the resolution of the corporate debtor has to take place, the consideration of the same would be by the committee of creditors and would require the approval of the committee of creditors by 66% vote. That we are all aware of. Second most important factor is in view of the judgment of the Honorable Supreme Court in Pioneer Urban Land and Infrastructure Limited and others versus Union of India, which actually dealt with the status of home buyers in IBC, wherein it stated that home buyers shall be treated as financial creditors under IBC. That was kind of an instigating factor, because Noida somewhere has to deal ultimately with the home buyers as well. They are the sub lessees in this transaction. So this was again one instigating factor. Okay, so the contentions on law that were discussed in this judgment are as follows. The honorable bench of the Supreme Court has dealt in great detail in the definition of section 5(8), that is of a financial debt. The construct and drafting of section 5(8) is such that it has two parts to the definition. The first part states the meaning of a financial debt, and thereafter the second part has the inclusions, wherein it states a list of debts and transactions that would be treated as a financial debt. So the contention of one of the counsels appearing on behalf of the appellant was that the financial should be the authority, which is Noida, was a financial creditor simply on reading the main context, the meaning of 5(8). We have reproduced the same for the convenience of the participants. So the meaning states that section 5(8), financial debt means a debt along with interest, if any, which is disbursed against the consideration for time value of money. So this is the extract of only the first part, which states the meaning of a financial debt. So as per the reading of the definition, we can identify certain essential requirements that need to be fulfilled to ensure that a debt is a financial debt, which are: first, there should be actual existence of debt, right? Second, the charge of interest, if any. However, the liability to pay interest is not an essential feature of financial debt, and this has been held by the Honorable Supreme Court again in Orator Marketing Private Limited versus Samtex Designs Private Limited. So this was a judgment which stated that interest is not an essential component to ensure that a debt is a financial debt. The third part, or the third ingredient that is to be seen, is disbursement, which is very important in the context of this judgment particularly. And the fourth is it must involve consideration for time value of money. So it's always said that in a financial debt, what is your consideration? It is the time value of money. That is, you're lending the money for a certain time period and you're charging a certain rate for that. So that is the consideration for time value of money, which is an ingredient, an essential ingredient for a financial debt. So only if all these conditions are met, can we say that a debt would be categorized as a financial debt. Now let us analyze this in the context of this particular transaction of the lease, right? So first factor is existence of debt. There was actually no dispute regarding the existence of debt. The only factor that was disputed is how this debt would be categorized. That is, would it be an operational debt or a financial debt? So the honorable bench did not go into this because this was an undisputed matter. Second, charge of interest. So in this context, there was a charge of interest. So again, that remained undisputed. Third point is the most important in view of this judgment, that is disbursement. So it said that each financial debt must involve a disbursement, and it is an indispensable requirement to constitute a financial debt under section 5(8). Second, disbursement, they also analyzed how would the disbursement flow. Like in this context, the lessee, which is the corporate debtor, would have to pay an amount, right, as a initial down payment, that is 10% amount of the total consideration. So the appellants contended that this 10% payment is actual disbursement, because we are giving a kind of a loan to them by way of, a financial help to the lessee by allowing them to give a certain part of the consideration, that is 10% part only of the entire consideration upfront, and thereafter 90% would be given on time-to-time basis on particular intervals. So the appellant said that this actually is kind of a financial help that we are giving them. So they said that this actually involves disbursement. However, the honorable bench held otherwise. They said in case of a disbursement should only be from the creditor to the debtor and not vice versa. So consideration should always flow from the creditor. That means the creditor should give some amount as a disbursement to the creditor, financial creditor, for it to constitute a financial debt. They also said that the definition of transaction actually goes both ways. So it says any amount of in asset or fund that is transferred from or to the corporate debtor would be treated as transaction. And the counsels appearing for the appellant said that this definition of transaction would also be extended, or rather should also be extended for the purpose of disbursement. However, they said that this would be too far-fetched and it would take a lot of unrequired transactions in its ambit for financial debt. So the honorable bench decided against it. So what summary we can draw from this point is, whenever you are deciding if a debt is a financial debt, you must ensure that there is a disbursement, and that disbursement shall flow from the creditor to the debtor only. It can never be vice versa. So since the disbursement point, so like I said that all four criteria are to be met, only then the debt would constitute or actually be regarded as a financial debt. So since the part of disbursement was not actually met in this context, so they said that this does not particularly fall under 5.8, the meaning part, unless there is a specific inclusion in the definition of financial debt regarding this transaction. So 5.8 part was discussed in negative. So they said this does not fall under the meaning of financial debt. Now we'll move on to the inclusive list and the relevant parts of the inclusive list and analyze if it is actually this transaction forms a part of this inclusive list. Okay. So in the inclusive list, the closest that appeared to this transaction was section 5.8D, which specifies that any amount of liability in respect of a lease. So since this was the lease transaction, this was the closest to the inclusive list. So any lease or hire purchase contract which is deemed as a finance or capital lease under the Indian accounting standards or such other accounting standards as may be prescribed to be considered as a financial debt. So they said that any lease, but such lease which is deemed or considered to be a finance or a capital lease under the Indian accounting standards. They did not leave this open. The statute did not leave it open to the court's interpretation that what would be categorized as a finance lease. They said that you have to refer to the Indian accounting standards to understand what would be included or what would be treated as a finance or a capital lease. Therefore, what we would have to do to understand this part of the definition is that we have to go into the Indian accounting standards or the Ind AS. And rule 61 to 67 of the Ind AS actually deals with the entire scope or deeming provisions that would make any lease a finance or a capital lease. So we'll analyze each of the rule one by one and see if the conditions are met for this transaction. So rule 61 is fairly simple. It says that the lessor shall classify, lessor in this context means Noida. Noida shall classify each of its lease as operating or finance lease. In this case, it was a clear contention of the appellant as well that there was no classification of a lease as a financial lease. So they said that since Noida has not classified this under this specific rule, which is rule 61, they cannot be treated as this transaction cannot be treated as a finance lease. Rule 2 would be taken up later in the process, wherein rule 62 and rule 65 are discussed together. Rule 63 sets forth certain examples or situations, either individually or combined, which would lead to a lease being classified as a finance lease. So it actually states certain examples or illustrations of a financial lease. So 63A says lease transfers ownership of the underlying asset to the lessee by the end of the lease term. Which means, if suppose we enter into a lease transaction and as per the terms of the lease, if at the end of the lease period, the ownership of that subject matter or that asset which is involved in that lease gets transferred to the lessee who actually had the lease, then that would be deemed or be considered as a finance lease. In the context of this matter, the lease deed did not contemplate any transfer of ownership of the underlying asset. Underlying asset for the lease deed, like we discussed earlier as well, was that land parcel that was there. So it did not involve any specific term that said that the underlying asset would get ultimately transferred to the corporate debtor, which was the lessee in this case. And no third party right or third party or means the home buyer has had the right to ownership in the same. So neither the lessee nor the third party or the sub lessee in this case had any right to ownership. The rights were transferred only for a particular land unit for a particular time period to the sub lessee as well, and again for a particular time period of lease only. So there was no extension or transfer of ownership. So this condition was answered in negative. Second is 63B, which deals with lessee has an option to purchase the underlying asset at a price lower than the fair price. So first condition said that you're transferring the ownership entirely at the end of the period. Now this condition says that the lessee would have an option to purchase the underlying asset and at a price lower than the fair price. However, as per the terms of the lease in the involved matter, the lessee had no right to purchase the underlying asset, which was the land. So there was no question of it being lower than the fair value. So what that lease deed said is that after the expiry of 90 years, you have to actually transfer back the property, the underlying asset to the lessor itself, which is Noida. No option of repurchase. Next is 63C, which says lease term is for the major part of the economic life of the underlying asset, even if title is not transferred. So what this says is, okay, fine, you're not transferring the asset at the end of the time period, or you're not transferring ownership of the asset, but the period or the term of the lease is such that it actually deals with the entire or a major part of the economic life of the land. So, which means that once the lease period would get expired, most of the asset would get extinguished or would not really hold value. Now, discussing this in the context of this matter, they said that for the lease in question, the period was 90 years. Now, on the face of it, 90 years would seem like a very long period, time duration. But what the Supreme Court held is that in a case where land is concerned, land has no particular identifiable economic life as such. So understanding the principle of a substantial or major part of the economic life would be difficult for an asset such as a land, since we all know land's value never depreciates. So land has an unlimited or a non-quantifiable economic life for that purpose. So therefore, this provision said that 90 years, whereas in a subject matter of a land, would not actually constitute a major part of the economic life, since the land does not have a finite economic life itself. Next is 63D. 63D says at the inception date, the present value of the lease payment amount to at least substantially all of the fair value of the underlying asset. So this says that the amount that you're paying as lease would actually constitute an entire consideration or the fair value of the land, of the asset itself. Now, on this term, as per the terms of the lease, they said that on the commencement date, what is paid by the lessee was 10% of the premium, right? there is neither a transfer of ownership at the end of the lease term, or there is no, complete title to the land. So in this context, they said that actually there is no option to purchase. So even if determining the amount of premium would not be relevant, because even if they pay the entire amount, they're not getting any right of ownership as regards the underlying asset. So again, this term was answered in negative. The last condition under Rule 63 is 63E, which says that the underlying asset is of such a specialized nature that only the lessee can use it without major modification. This is a kind of a residuary provision or a specialized provision which captures only specific and really extraordinary kind of assets being involved. However, since this particular lease did not involve such a specialized asset that can be used only by the lessee without modification, therefore this was answered in negative. Next rule involved is Rule 64, which continues with certain situations again, which would lead to the lease being treated as a finance or a capital lease. 64A says, if the lessee can cancel the lease, the lessor's losses associated with the cancellation are borne by the lessee. So in this case, they say any transaction of lease wherein the lessee, in this case the corporate debtor actually, if the lessee has the right to cancel the lease, and the losses of the lessor are to be borne by the lessee in case of that lease, then that would also constitute a financial lease. However, as per the terms of this particular lease with Noida, there was no term in the lease deed that actually stated that the lessee has the right to cancel the lease deed. In fact, on the other hand, the lessor was the one, that is Noida was the one who had the right to cancel the lease. However, the corporate debtor, being the lessee, had no such right to cancellation. So this was not met. 64B, gains or losses from the fluctuations in fair price of the residual accrue to the lessee. There was no term in the lease deed regarding fluctuations in the fair price or the losses that would accrue in that regard. It was limited to the purpose of construction of the residential units only, and the right to sublease it subject to certain conditions. So it did not cover any fluctuations. So this was not applicable altogether. The last condition in Rule 64 is lessee has the ability to continue the lease for a secondary period at a rent that is substantially lower than market value. So if it says that if even after the expiry of the lease term or duration, if the lessee has the ability or the option to continue with the lease for an additional time period and at a lower rent, that would also constitute a financial lease. However, in this context, there was no condition for renewal of lease. So it was for a fixed time period of 90 years and had no right to renewal. So no secondary period was contemplated in this. Very important context now are Rules 62 and 65, which actually state the essence of what is the meaning of a finance lease. Okay. So Rule 62 and 65 state that any lease, and hear me out correctly here, lease may be classified as financial lease if it transfers substantially all the risks and rewards incidental to ownership of an underlying asset. So it says that even if all the conditions stated in Rule 63 or 64 or any of the conditions are not met or illustrations are not met, the main constitution or the main logic behind a financial lease is that it should transfer substantially all the risks and rewards, both of them, the risks and rewards associated with the ownership of the underlying asset. Each word over here has its own importance, and the same was discussed in this judgment. So they said that this rules revolves around the transfer substantially of all the risks and rewards Ordinarily, a finance lease would be a lease which is born as a lease, but So when you enter into it, it is a lease. However, it culminates or ends up into a sale. That is the idea behind a finance lease. And thereafter, they also interpreted the word substantially. So what would substantially mean in this? So even if I transfer, say, 5 rights or 6 rights out of the 10 rights, would that mean substantially? So they said no, largely and in substance, all the risks and rewards associated with ownership of a property, of the underlying asset, should be transferred. Only then it would constitute a finance lease. Now in this context, with regard to a land, there are certain rights an owner enjoys, which includes, some of them are right to ownership, right to title, right to actually give it forward or enjoy the ownership of the property. So these are certain rights with regard to a property being a land. So however, in this context of lease, the terms of the lease deed were such that there was a conditional reward to the land. There were conditions on the lease which included the right of the lessor to terminate. So only the lessor could actually terminate or cancel the lease. Thereafter, no right of assignment was given to the lessor under clause 12 unless subject to the consent of the lessor. Then the premise could be used only for residential purpose. Then the permission of the lessor for sublease of the property. So whenever the lessee had to sublease the property, it had to actually take the consent of the lessor. Thereafter, no mortgage could be created by the sublessee. Sublessee in this case being the home buyer, unless the consent of the lessor was obtained, which is Noida was obtained. Then conditions on subdivision, wherein it said that the land could be divided only in the parcels of 20,000 square meters. That was the limit, and not less than that. Then sublease to be governed by transfer policy, and only transfer of rights. This was what Supreme Court observed, that there was actually a transfer of risk, but a limited transfer of reward as regards this particular transaction. Therefore, even if there was a transfer of risk, the essential element of this rule, that there should be a substantial transfer of risks as well as rewards. So the rewards conditions was not met, and therefore this condition again in this rule was not met. So they concluded that this transaction cannot be treated as a financial lease, and since it is not a financial lease, it cannot form part of the section 5A(d) inclusion. Now the last part that was discussed is section 5(8)(f), which is actually a residual kind of an inclusion, wherein it states that a financial debt includes any amount raised under any other transaction. Since it is residuary, it uses terms like any other transaction, including any forward sale and purchase agreement. These are just illustrations, having the commercial effect of a borrowing. So effectively what it means is, any amount that you raise under any transaction which has a commercial effect of a borrowing would also be treated as a financial debt. Now, what is important here is it deals or states the term transaction. Transaction is defined under section 333 of the IBC, which says that it includes an agreement or arrangement in writing for transfer of an asset, funds, goods or services from or to the corporate debtor. So this involves a two-way flow, right? So which would mean that if I enter into any such transaction under any agreement or any arrangement in writing, and if it has a commercial effect of a borrowing, then that would actually be treated as a financial debt under the IBC. Referring to the judgment of the Honorable Supreme Court in Pioneer Urban Land and Infrastructure Development, Pioneer, a very famous Pioneer judgment for home buyers, the appellant contended that if the home buyer could actually be treated as and covered under the definition of under the ambit of section 5(8)(f) as a financial creditor, then the Noida authority, being the appellant in this case, should also be included as a financial creditor. This was one of the contentions used by the appellant. Thereafter, it also went on to say, these are all the contentions of the appellant with regard section 58F, which states that the appellant contended that amount raised by the lessee is in that manner is, so they said that we are giving an upfront payment, like I stated earlier. And they said that this upfront payment is kind of a financial help that we are giving them, that you do not make payment of the entire consideration of the land, but just give us a premium, and then thereafter, after a 2-year moratorium, then in a staggered manner, you pay the consideration for the land. So the appellants contended that this is actually a financial help or a way of fundraising that we are giving them. So they said that instead of taking a loan, what the corporate debtor was doing is it was just making a part payment to us upfront, and thereafter was making payment in bits. So this was the main contention taken by the appellant for 58F. And thereafter, going into the context of financial creditor, it said that since we also, I mean, Noida also looks in the long-term perspective and long-term interest for while giving any leasehold property, and that is the intention of a financial creditor, then we should also be treated as a financial creditor. However, the honorable bench said that it is unable to hold the context or the contention of the appellant that the lessee actually raised an amount from the appellant. There was no raising of an amount. It is just that the payment was designed in such a manner that it has to be made in a leased manner. However, there was actually no raising of fund by the appellant in this matter. Now, since if we go back to 5.8, it says the amount, any amount raised. So since there was no fundraising involved in this particular transaction, the Supreme Court said that this cannot be covered under 5.8F as well. The last part of the judgment said whether the appellant is an operational creditor. So, but the honorable bench held that since both the NCLT and NCLAT had actually held that it was the appellant was a operational creditor, and that was not the main question or main contention involved in this particular, these two appeals. Therefore, they did not hold any or did not give any specific comments on this question. So this was the brief of the entire judgment, and what impact does it have is that there were a lot of matters pending, a lot of CIRPs pending just because of this question of law being unanswered, wherein Noida had always contended that they are to be treated as a financial creditor. Now, after this judgment, these CIRPs would actually sail through, and a lot of a lot of matters would get resolved speedily now. Thereafter, second most important point in favor of the home buyers is that it gives an edge to the home buyers above the Noida authority itself under the IBC, which is a very positive action or a positive news for any home buyer. And one of the officers of Noida had also reported that a review application or a curative plea in the Supreme Court would be filed by the authority against this order. However, as on the date of this webinar, there is no such news of an application or such a review application being filed before the Honorable NCLT. Honorable Supreme Court.
Thank you, Jasveen. It was really wonderful. Thanks a lot for your elaborate discussion and the presentation. It was in-depth and well in time you completed, as we discussed, that we'll try to see. And as we saw, a lot of questions in detail you have answered, and the Supreme Court has tried to clarify. So this, Mr. Ganti, would you like to say now that since the presentation is over?
Yes, thank you, Dipti. Thanks a lot. Congratulations, Jasveen. You did a wonderful job. I mean, there is nothing left for us to say, actually speaking.
Thank you, sir.
Wonderful, wonderful. Okay, now, so I would want to comment going beyond this, what happened in the judgment, to the likely fallout of the judgment, in addition to what you said. Till the other day, till before this judgment came in, landlords and leaseholders, I mean lessors, could not actually initiate a Section 9 because they were held to be not OCs by inclined judgments prior to this. Now that window opens for any lessor that if they want to, and provided they fulfill all the eligibility criteria, that they can actually initiate. Noida itself, for example, could now go ahead and initiate a Section 9 application, or MIDC for that matter, or GDA, or any such large lessors who have dues, defaults of debt of 1 crore or more. So that's one thing. Another comment I would like to make, because the last word is not yet said on this. If you look at the last para of the Supreme Court judgment, they have in a way said, without saying so much, but just saying it on the other hand, like a good economist says, that this may not necessarily be a OC, but because NCLT and NCLAT have held it to be so, and because an OC supposedly gets a better benefit, अभी के लिए हम ये मान रहे हैं, you know, for the time being. So when this such an issue, not this one, but an issue of a lessor like this does come up in a substantive way tomorrow, things might change to the extent they might say, finally say, okay, that was obiter dicta. We didn't really judge it because the only issue before us was Noida, is it FC or not? We answered in the negative.
Yeah,
we did not really answer the other part fully. We just accepted as it is. So that's one thing. So there are two fallouts to this. One, it does open as of today a door, but that door might close tomorrow.
Absolutely.
So जब तक खुला है तो advantage ले.
Right.
Yes. And okay, but one part of that line in that last para, on one of the grounds which they said that an operational creditor enjoys certain advantages over other creditor. I couldn't really understand what advantage is there in law. It doesn't exist, except for the fact that if your OC has 10% or more dues of the total debt, you get a gallery seat to watch the match from the pavilion. Otherwise, you are doing it from outside. Other than that, और तो कुछ है नहीं, because Section 53 does not differentiate between the two at all.
Yes. So, but in the resolution plan, there is a specific condition that says that operational creditors should be paid above the liquidation value at least. That is to be ensured.
No, that is being misunderstood. See, it is like saying that Ram owes Sham 100 rupees. You can also write it subsequently that Sham has to receive 100 rupees from Ram. Both mean the same thing, but it has been said twice. But in addition to that, I also say Sham has to receive 100 rupees from Ram, and Ram shall not pay anybody else before paying Sham. Now that the second part is what is the difference. It is the order of payment, not the ranking of payment.
Yes.
Ranking of payment both fall under 53(1)(f). General OC, other than employees, workers, government, which fall higher or a secure, and any other claimant, which could be a not an operational creditor by definition. They all are their liquidation value. Liquidation value, if it is payable for both equally. In the same order, both are under 53(1)(f). So that really doesn't mean anything. That is a misunderstanding of the law. Once you go into depth, you realize that other place where it said that OC shall be paid in priority and minimum liquidation. That and minimum liquidation value was meaningless. It need not have been written. Once you have Section 30, subsection 4, it is included in that. There was absolutely no. But bol diya to bol diya. The danger with such telling things which are obvious is that it might be misunderstood, which is what is happening. तो हमारे लिए काम बनता है ना misunderstanding.
Okay, participants, if any question in that chat box, there is no question. Our other participant has already given the link, so we have not to work on it. If any question is there, you can just unmute or we will close the session as permitted. I'll try to be always in a timeline.
Ma'am, I have a question.
Please.
Yeah, it is still unclear whether Noida is a secured creditor, whether it is a secured or not.
Jasveen?
Yes,
sir, Mr.
Okay. Secured creditor is created either by contract or by operation of law. Okay. In the case of Noida, from whatever is there in the judgment discussed, we can't make out whether they are secured or unsecured. But there could be a local law which gives them secured creditor status. Like, for example, if it was Maharashtra, then in Maharashtra, for example, property tax dues are having first charge by operation of law, subject to any central act in relation to charges. Similarly, in certain states, such revenues, which are lease rents, etc., they could also be recovered as land revenue, arrears of land revenue. Now, arrears of land revenue by itself does not create a charge in terms of Section 48 of TOPA. But in this particular case, from what we have, we don't know. It might be, it might not be. But that was not the issue before the court in any case. The issue was whether they are an FC or not an FC.
It would depend on the terms of the lease to say so.
But it may impact resolution plan. Had it been a secured creditor, they will have the right on the liquidation value.
Oh, no. Okay. If you, no, no. Okay, you mean the ranking would be at 1A and not
Yes.
1F, where they now rank. That's true. That is as far as the past dues are concerned. Yeah, absolutely. Anybody with a secured interest will rank higher in the hierarchy. But the fact is that the ownership is still with them. And that was the entire part of this judgment, that the owner, there is no transfer of ownership in any manner. So while they may not have too much of may not get anything in terms of past use, they have full control on what happens in the future. See, you can't ignore the owner and do get any resolution plan. And this is, I cannot understand why Noida is in any way wanting to do all this litigation unless they were interested in just litigation for that sake. Because an owner has absolute right. No plan can be approved which is against the interest of the owner. Future interest. Past one is dealt with under subsection 30 or section 30 or section 53. Future, every
interesting point raised. Yeah. Any other question, please? Yeah, sorry, Mr.
GDA, Noida, all depending on the specific terms of the lease. I can tell you in Uttar Pradesh, all lease agreements are not identical. Now, this particular one had a 90-year period specified, which had a cancellation clause. There are lease agreements which specify payments up to a certain point. After that, transfer. They are there. And then the land becomes freehold land. So it is individual transaction which will decide.
That's not the case, actually.
Yes, and adding to what ma'am and sir have said, it would only depend on the terms. Even in this context, we're just trying to analyze or deliberate how we have to read the law in that matter. But facts will vary from case to case basis. Even for an agreement with that Noida has with another lessor, it may vary. We never know.
There is a question: is Ghaziabad Development Authority treated as operational creditor or secured creditor?
That's what I answered.
Okay. Any other question?
Facts of the case will decide.
Any other question, participant? Okay, I think there is no question. Thanks a lot, everyone, for all your time. And this we will continuously coming regularly for different topic. And we will inform you in advance. Please join us and share each one of us our learning. We all are friends learning from each other, and we share the experience. So it will be, if interactive, we'll enjoy this session. Thanks a lot. Thanks, Mr. Ravi. Thanks a lot for your time.
Thank you.
And inputs. Jasveen, fantastic presentation. Lot of efforts. Really, very good efforts. Thanks.
Thank you. Thank you so much.
Thanks.
Thank you. Thank you. Thank you so much.